Good afternoon, everyone. My name is Ala McCoy. I am Director of Startup Support at the University of Maryland Ventures. And I would like to extend a warm welcome to everyone who joined us today for the next installment in Startup Fundamentals Workshop Series, both our live webinar audience and those watching a recorded version on our Startup PMD YouTube channel. This workshop series is offered by Ventures and Maryland Technology Enterprise Institute at the University of Maryland. Everyone in the live session, please feel free to submit questions using the Q&A function. You can usually find it at the bottom of your screen. Remember that we are recording this session. It will be posted on YouTube. So if you would like to remain anonymous, you can submit your questions anonymously. So today, I am very pleased to welcome Scott Bettridge. Scott currently serves as the chair of the Cozen O'Connor's immigration practice and represents both corporate and individual clients, all in all aspects related to U.S. immigration law. Thank you, Scott. And Elizabeth Oliveira. Elizabeth's practice focuses on employment-based immigration for institutional clients and multinational corporations, also with Cozen O'Connor. So thank you so much, Scott and Elizabeth. I'm gonna stop talking, give the microphone to you. And you can give more details about yourselves. I usually don't like reading people's bio. You can talk about yourself much better than I can. I'm very much thankful for your session today. Very, very important topic, especially at a university where a lot of our postdocs and a lot of our graduate students are coming from other countries. So thank you so much. Very timely topic.
Oh, thank you so much for having us today. I'll start out, I guess. As Alan mentioned, my name is Scott Bettridge. I'm the chair of Cozen O'Connor's Immigration Practice Group. I'm based in the firm's Miami office. I've been practicing solely immigration law for over 30 years. As Alan mentioned, both in a corporate and individual context, and that includes things like non-immigrant visas, permanent residence, green cards, labor certification, citizenship, EB-5 investors. We do have a specific focus on more global workforce mobility issues, mergers, acquisitions, startups. We also represent a lot of individuals with entrepreneurial options, family-based options. So we're pretty much outside of litigation and more individual challenges based on personal matters. We pretty much handle everything. I'm joined by Beth. She's an associate attorney who's now based in our Minneapolis office, was in our Chicago office for a number of years. She plays a significant role on our team in all the types of matters that I mentioned. She does have a distinct focus on issues related to small and mid-sized employers, as well as individuals, where I think she really is excellent at developing more tailored immigration solutions to fit individuals' needs. Beth, you want to add anything before I can kick it off?
Oh, that was great. Thank you.
I'm going to start. I think obviously we're here today to discuss immigration solutions for startup founders. I always like to be clear at the outset, the topics that we're going to be reviewing today are going to be general in nature, meaning, what are the options? What are the types of visas? What are the general qualifications? What issues can arise, both good and bad, for any chosen immigration option or path? There may be options that we'll talk about that prospectively apply to everyone online today or watching this later, or others that really only apply to a select few. As Alan mentioned, we'll welcome any questions. We do have a PowerPoint that we're going to go through briefly. I don't like talking about the PowerPoint. This is more for your takeaway at the end of this session to take a look at and kind of provides more of an overview. But we'll share that with all attendees. And even if we can't address any of the questions or all of your questions today, you can certainly feel free to reach out to Beth or I in the coming days or weeks to discuss any individual questions as needed. I think our contact information is at the end of the PowerPoint. So I trying to think of a great way to say it. I'll begin, for those involved in or who are like you, perhaps observing the U.S. immigration system currently, it is undoubtedly a crazy time. We're seeing, in some instances, unprecedented or record high case backlogs. There's evolving political or policy shifts. There's a lot of issues related to heightened enforcement. Many of our companies, are worried about ICE visits on site, how that impacts not only companies but individuals on site, and just an overall somewhat tense political environment as it relates to immigration. A lot of immigration policies, a lot of new policies, have caused a bit of uncertainty. There's been a handful of inconsistencies which have impacted both government decision making, processing times, as I mentioned. But these ongoing issues, or we sometimes refer to them as complications, I'll call them. We do our best to try to provide clients with a general, more common sense approach or roadmap to guide them through each step of the process, which I think if you take a deep breath and we step back and we look at regulations and we try to block out all the policy issues and environmental issues in terms of the heightened sense of immigration at the point, we're able to lead our clients to approvability of their visa applications in the majority of instances. So, looking at the first slide, can foreign entrepreneurs invest in the U.S.? And that answer is undoubtedly yes. Foreign entrepreneurs can invest in the U.S. They can establish or invest a U.S. business, and be eligible to obtain investor visas. I'm going to talk a little bit about the E2 treaty investor. There's the EB-5 immigrant investor visa, which is on the green card side, both of which allow individuals to reside and work in the U.S. Foreign ownership of U.S. companies is generally unrestricted, meaning, there are specific visa requirements that apply if the entrepreneur plans, obviously, as most of you will, plan to live and work in the U.S. But there's many ways for a foreign entrepreneur to invest. So let me just be clear: you don't need to be a U.S. citizen for ownership. Citizenship is not required for ownership. You don't need to be a citizen to form or own your own business. The process is the same for non-residents as it is for citizens. The key takeaway, however, is that a mere investment alone into a U.S. entity does not give that investor the right to remain solely in the U.S. just based on that investment, right? So you can be an investor very similar to, investing in the stock exchange. You're a passive investor and you can invest, but just because you own stocks it doesn't give you the right from an immigration perspective to live here. So we're really going to discuss several visa options that are available for individuals seeking to invest in the U.S. business, but also have the ability to stay here and work. And I think the key one that I mentioned before was just the E2, which is a treaty investor visa. And this is simply nationals of countries that have a treaty of commerce and navigation with the United States. This is what's called a non-immigrant visa that allows you to live and work in the U.S. by making a substantial investment into a U.S. business. The EB-5 investor visa that I mentioned, that's separate. That's what's called an immigrant visa. And that allows foreign entrepreneurs to obtain permanent residency, a green card, by investing a significant amount into a U.S. commercial enterprise that creates at least 10 jobs for U.S. workers. That amount right now, depending on EB-5 where the projects are located, could be 1.05 million, or it's reduced to $800,000 in targeted employment areas. I'll mention it very briefly when I mention EB-5. The quick point, just on the gold card option, which you may have heard of or read about. I remain very skeptical about that program altogether. While the most recent press conference, and I did watch it, we're going to be awaiting more details of that implementation. I think this is going to be in about 60 to 90 days, but I don't envision that any gold card program would ultimately replace the EB-5 program, but I think it would rather supplement it. It's designed and clarified as right now as what appears to be the equivalent of a donation to our government to reduce our national debt. Um, maybe there's some specific, potential tax consequences, beneficial consequences from a tax perspective by going through that program, but we'll see. So, I mean, we're promised we'll hear more in 60 to 90 days. I remain skeptical. It may become an option, but we're not going to really get into that in any additional detail today. We will touch upon a little bit, and we'll cover it in the PowerPoint, the international entrepreneur role. That's something that allows foreign entrepreneurs to obtain a parole. It's not a visa, but it's a parole that allows individuals to come into the U.S. for up to 5 years if your business, your startup, demonstrates potential for significant growth, rapid growth, and benefiting the U.S. economy. So, Beth and I will touch on that a little bit more later. For most of these paths, I think it's important to know, a passive investment generally does not lead to long-term options in the U.S. There are those that say that EB-5 is passive, and I don't necessarily disagree with that. You're either an active investor or a passive investor. In the EB-5, you're what I like to call a limited investor, as opposed to an active investor. But an active investor is key as we look at things such as an L1 visa. I'm not going to touch on that much today, but that's for more active managers and executives and transferring into the U.S. While I think the e-visa, sometimes an e-visa manager can be seen as more passive, but it's definitely not the case when the e-visa is for an individual owner or investor of a startup or small company. You can go to the next slide, Alan. So I think as we look at the key steps, review these key steps. Many of you know these already. Many of you may have explored these already. Again, the structure of a business and choosing the right structure. From an immigration perspective, in general, any structure can be adapted for immigration purposes. So it's not as if in order to qualify, your business must be an S Corp, a C Corp. Anyone can be adapted. It could be a partnership. It could be an LLC. So, I guess would say from a tax perspective or other reasons, one form of doing business may be a better option for you than the others. So, but you're not, I just want to be clear to point out, it's not something that would restrict you, from an immigration perspective. Registering and obtaining your FEIN, these are pretty quick, generally quick and painless steps, provided the name you're choosing isn't something that's already in use. I think opening a bank account is pretty important. Contrary to some belief, foreign entrepreneurs can open bank accounts, though the process to do so would first require you to form the U.S. entity, obtain your FEIN, and provide additional documentation. Many times you have to show passports or business formation documents or proof of a U.S. or foreign address. Traditional banks, I'd say, are difficult sometimes for non-residents, but there are many different online banking platforms, fintech companies that offer easier access to accounts. They streamline the process, they simplify the process. I think some still do have a physical visit for the most secure scenario, but as immigration attorneys, we can always refer you to some banking institutions that we're aware of. Our foreign nationals have worked with and been successful previously, but we're not necessarily involved in that. Sometimes the bank wants a letter from us to confirm that the individual's in lawful status, or to confirm they've engaged us, to know that we're assisting with the process to give them more security in terms of opening that account. And we're always happy to do so. But generally, once these steps have been completed, then the immigration options can be explored. I'm going to clarify. Immigration options can absolutely be explored in advance of these steps, but practically speaking, we can't advance on those immigration options until these steps have been completed. There's some other steps that, we would probably advise, like having a principal place of doing business, Generally that involves like a corporate lease for business premises. Currently, immigration, USCIS does not like full work from home, so they're always going to look for a principal place of doing business. And obviously, from the immigration side, they're also love to see business plans. They fully anticipate that employers in the U.S., whether you're a U.S. citizen or not, before you begin a business plan, before you begin a new business, that you've decided how and why and where and when, and you've done market analysis and research to determine that, and compiled that into a formal business plan. I think the key to many startups is that business plan. Yeah, you can go to the next slide, please. So I think we'll just jump right in on, is this the right one, Beth? I thought we were going to go to E's.
Yeah, I thought E was next, but maybe that got mixed up. That is E. Okay, yeah. I can go back to OPT in a second.
Yeah, we can go back to OPT. I just really wanted to personally get involved in the E visa. This is something that I spend a lot of time on. Personally, I think it's a very viable option for many foreign entrepreneurs. And I want to be able to jump into this and spend, as I said, a little more time on this. I just would preface as well by saying that as we review these temporary visa options, I mentioned it briefly before, but I want to be sure I'm not misinterpreting something for anybody. But clarifying the difference between what we call a non-immigrant visa and an immigrant visa. A non-immigrant visa are those temporary visas that are issued for a specific duration. We'll talk the H1, the L1, the E2, the O1. It's the alphabet soup of options here. When we say immigrant visas, on the other hand, those are applications for permanent residence, green card applications. Non-immigrant is temporary, immigrant is permanent. You can hold a temporary non-immigrant visa and concurrently apply for an immigrant green card visa. But I just want to clarify. So like the E2 and things that we're going to discuss first here are considered to be non-immigrant visas. So a foreign national who is a citizen of an E1 or E2 treaty country can obtain an E visa that allows them to enter the US in a short period of time. E visas are non-immigrant visas. As I said, they allow an individual to own and operate a business in the United States. The key when I say treaty country for a US E visa, a qualifying treaty of commerce and navigation must exist between the US and the individual's country of nationality. The E1 is what's called treaty trader, and the E2 is a treaty investor. Treaty trader is where the exchange of goods and services is more than 50% from your home country, meaning you have an import-export business and you're selling widgets, but the widgets as a UK citizen are all coming from the UK. More than 50% of those widgets. While the E2, a treaty investor, that's where more than 50% of the capital that's invested into the US business comes from a specific nationality. Both visas require the individual to obviously come, as I said, from a country that has a treaty, and then qualify and quantify, if you will, that specific trade, the amount of trade, or the investment-related purpose of the business. These e-visas can be granted on the average for up to a 5-year period. It allows for multiple entries into the U.S. and every time that you enter the U.S. on an e-visa, you're able to be extended for 2 years at any one time. There's no limitation on how many times an individual can apply for an extension of an e-visa. And an E2 investor can purchase an existing business or franchise. An E2 investor can take a passive or active role in the management of that enterprise, but has to have at least 50.01, I like to say 51% ownership of the U.S. company to show they're in a position to make major decisions and control the U.S. operations, meaning you're not just an investor by financial means only. You need to show that you have a sufficient activity into the entity, because I said controlling and directing the U.S. operations if you would like a successful E2 application. The E2 company can hire U.S. employees at any level of job titles. There's no restriction, and generally a successful E2, and especially on renewal, there will be U.S. employees that are hired by that E2 entity. I'd make a quick note, I know I mentioned the 51%. I'd be careful. As with many startups, dilution can occur as more capital is raised and obviously brought into a new business. You want to be careful to always stay at or above the 50%, or the e-visa technically becomes invalid, which really becomes a problem at the time of visa renewal, if not earlier. If it drops below that period, that 50%, it could be deemed that anything beyond that period is technically in violation of your e-visa. And that could really be throw a big wrench into your immigration compliance. I think it's worth mentioning that you can also come in as a critical employee of a foreign-owned business, so long as you share the same nationality. In that kind of path, you don't necessarily need to be the investor or the owner of that business, but you could. Excuse me. For example, I mean, like you're a British citizen that's coming to work for a majority UK-owned entity in the US. French citizen coming to work for a French company. L'Oreal, I'm trying to think of you can obtain an e-visa as essential support personnel, even if you're not the specific owner, the 50% plus owner, so long as it remains owned by individuals of the same nationality. Conversely, if you're a UK citizen and you establish an E entity, you can hire other UK nationals as essential support personnel under an E-visa as well. When you establish an e-business, it doesn't have to be very large. There are many e-visa cases that we do for consulting companies, for web design. Doesn't mean that you have to be manufacturing computer chips. You don't have to be manufacturing automobiles. It could be that you're providing consulting services, law services, accounting services. The problem becomes that in those kind of contexts, sometimes putting a monetary value on the investment amount required to get the e-business going is somewhat not substantial enough to meet the E2 requirements. So it's important to know it doesn't have to be very large, but there has to be an investment that's required for that business. I'd want to mention, I guess, I know we're not going to cover the L1. It's not a significant option for foreign students, like many of you are. The L1 it has a different set of requirements, but it is somewhat similar to the E. Basically, an L1 requires that a foreign national have been employed as an active employee, executive manager, if you will, for the foreign. It has to have a foreign business, a foreign entity that exists for a minimum of a year, and you show that you've been employed outside the U.S. for at least a year of that entity. Now you have a related startup in the U.S., and you may be able to effectively transfer yourself from that foreign entity to the related U.S. entity under the L1. Obviously, to prove managerial responsibility, we look towards, org charts, organizational hierarchy, if you will, to include other executives or managers that may be supervised. And again, I think it's important to look through a business plan to show and prove that you're going to be an active manager or executive with this, this U.S. subsidiary. L1s can be granted for a year in what's called a new office L1. And then again, hire additional executives or managers as staff within the year. I mention it because, again, I think it may be a small path for some, but not for others. You may be, you can maybe come from a family business abroad, and now you're going to open up a subsidiary of that business, maybe doing a completely different thing, meaning you have a business abroad, your family has a business abroad, selling automobiles, and you want to open a subsidiary to provide, similar services, but maybe completely different. You have to be related, but not directly in the same business. You could be doing automobile consulting, something along those lines, but be related, share common ownership, and look for as an L1 opportunity to transfer yourself, if you will, to that US sub. The L1 laws and policies, as I mentioned, require this organizational hierarchy, and sometimes carry a higher cost and overhead, and definitely operational cost than potentially the E2. The E2 does not require you to show employment abroad or have any managers or executives. You might not have any other employees in an E2, but you have to show there's other employees for the L1. And L1 requires a foreign entity to continue to exist. The E2 does not. I think a big benefit of both the L and E visas are that spouses of L's and E's are authorized for employment in the US incident to status. This is simply that basically once the foreign spouse enters the US under their derivative visa, an E2, that's an E2. For L1, it's an L2. They can work however they wish to work. They don't have to seek or apply for additional approval. They don't have to have their own employer-sponsored petition. They can do anything. They don't have to be related to their educational background. They don't have to have experience in anything they do. They have open employment authorization. So it really is a great benefit where, you have a startup that you're, getting off the ground and spending a lot of time and effort, but your spouse may be able to work and pay some bills while you're getting your startup off the ground. So it's a spectacular opportunity. It changed a couple of years ago, to have this open authorization. So I think it's a great point to mention, especially for, it's even a scenario where if you want your L2 or E2 spouse to work with you and pursue that entrepreneurial venture with you, they don't have to have those limitations. You might be under the US under a different visa. Maybe you have an L1 or E2 with a separate company, even as I said before, as an employee E2, and your spouse has the ability to work, they can start up a company without any additional limitations traditionally. So I think it's important. The E, as it mentions, it provides for an immediate timeline for entry in the US. You don't have to apply for the E2 or the E visa in the US. You can apply directly at a US consulate or embassy abroad. I think in most cases, I can say a smooth process can be obtained in about 60 to 90 days. Again, sometimes, and that's really from the time of filing. As I mentioned, you've got to obviously demonstrate through a business plan that the business will have a viable economic impact. You really got to show that you have the background sufficient to operate that business. And sometimes the E is a good opportunity because it gives the investor a chance to develop the business over a period of time. It gives you that 5-year path. It gives you that 5 years to maybe develop a more formal structure, necessary to pursue potentially a green card. As I want to be also clear, I know I just mentioned that, most E2s, most of them are processed at a U.S. consulate or embassy abroad. But if you're in the U.S., you're under an F1, you're on OPT, you can also change your status to E2 as well. If you do go down this path, it's generally viable. The next time that you do depart the US, you will need to again apply for a new visa stamp similar to your underlying F1 at a US consulate or embassy abroad prior to returning. So you can file to change your status. You can stay if you're approved. There's no reason to travel. But if you did, then you'd have to get a new stamp before you return. So I think just briefly, if I just backed up and just said, as we look at scenarios to evaluate eligibility for an E, first step, obviously, we look to determine our client's citizenship or nationality. We want to see if that treaty exists. And those treaties can be across the board. There's, as I said, treaties of commerce and navigation. I think there's friendship, there's bilateral investment treaties, there's the free trade agreements with Canada and Mexico. I'm often asked if and when new countries might be added for e-visa eligibility. My simple answer is that the most recent countries added, New Zealand and Israel, were both added in mid-2019. So it's been a good minute since any new countries or new agreements and treaties were entered into. But it's, things are always apt to change, especially now, as we've seen. Another key point I'd mention is that if you have a spouse with a different nationality, not only can your spouse work if you become the investor, but if you have a spouse, perhaps you're from a country that doesn't have a treaty, but your spouse has a different nationality, and he or she is from a country that does, they may be able to be the treaty investor, which then permits you to be the E2 spouse and have the opportunity to work. So I know it's again limited, but for those of you with spouses from a different country, it's worth exploring as well. And there's other scenarios, I'd say, where, and I mention this because there's some key countries, large countries of investors that don't have an E2 right now, such as India, China, Brazil. But there's opportunities, and I should say there's companies out there that specialize in helping individuals obtain citizenship by investment in treaty countries that might qualify for e-visas. You might be eligible for derivative citizenship through an ancestor or a family member. And once that's obtained, you can then become e-visa eligible. I see this, as I said, I'm based in Miami. I have a lot of Brazilian clients. As I mentioned, Brazil is not an e-visa country, but many Brazilians, I've come to realize over the years, have claims to Spanish or Portuguese citizenship through a family member. And once they can go through that process, it takes a little bit of time, as I've seen, perhaps upwards of close to maybe 6 months to a year. But if they can obtain Spanish or Portuguese nationality, get a passport, both of those are e-visa countries, and they can use that as their nationality to serve the e-visa process. So again, I say that for those of you that might not be looking at exploring immediate options, but maybe taking a step back and going down that path of derivative nationality right now might be a helpful, path to look into. Probably gone a little bit more off path than off track than what's covered in our slide here now, but I just think it's important to note just the E2 requires a substantial investment in the U.S., and that is prior to obtaining the visa and applying for the visa. It's not explicit in the statute, but I do think it's important that you have a business lease. Could be a WeWork, could be something like that, but having one gives credibility to your application. And again, I think as you look at it at the outset of an E2, as you look for an E2 renewal, so long as that business is running according to the business plan, employees have been hired, the renewal process is pretty straightforward. You show your tax returns, additional details about the ongoing business operations. I do recommend a lot, that also business owners use a more traditional form of essential or standard business documentation to protect their interests, but also to show that their business is doing well in the normal course. I mean, whether that's employment agreements for the staff, written contracts with vendors, contractors, non-disclosure agreements, etc. So those are all key documents that I think to maintain as you're going down that path as well. I'm going to stop there, Beth. I'm sorry for rambling on too long about
No, you're fine. I think everyone enjoyed that. Ella, if you
summary of I think it's a really good option to focus on. There's a lot of others, but as you'll see with changes in fees and costs and concerns, I think the E is something good to focus on. So I'll turn it over to you. Sorry for
no, I think that's great. And if anybody has any follow-up questions, our information is going to be, it was at the front and then it's also at the back of this presentation. So happy to answer individual scenarios. Ella, if you go back to the slide before this, I'm going to cover OPT really quick. And I know I noticed in the question and answer portion, there were a couple of notes in there. So I'm going to answer those during this part. Hopefully I think those questions are very good. I think it would apply to many people in these scenarios. So big question as an F1 student, OPT, can I work for myself? Can I start my business? Can I work for myself in that program? The answer is yes, you can. Self-employment is allowed for OPT period, for the 12-month OPT period. There are specific requirements. You do have to, like Scott said, go through the process of starting the business, doing the business plan, getting the FEIN, getting, you have your address all taken care of, opening up a bank account, that's recommended. One of the questions in the Q&A was, is it safe for me to start my business in the F1 status? Yes, you can absolutely do that. Is it safe for you to start a bank account and get an FEIN? Yes, you can absolutely do that. And like we said, or like Scott said before, the banking institutions, depending on which one you go with, will have different requirements. But as long as you show the information that they require, they should not stop you or have any issues with you opening an account. And, especially if you explain this is a business account related to the business I'm starting, that should not be an issue. And like we said here in the slide, you must be actively engaged full time in your business. So unfortunately, you can't start a business and not work for it in OPT. I mean, in theory, you could start a business and have, somebody else kind of, do the workings and everything. But if it's your business that you want to start and work on, it has to be the OPT program that you work on it through. You can't do something else and then also work at your business. Key requirements for self-employment on OPT, it must be related to your degree. So for instance, and we've had a lot of these questions come up in the past, where if someone is a computer science major and is getting a master's degree in computer science and they want to start something that's related to chemical processing or something that is not related. But if you start something that's, maybe like a tech company or something that has computer system analytical requirements, that should be totally fine. So just thinking about those things, and remembering, it should be related to your field of study. And especially when we talk about MBAs, I think that gives it a little bit more of a broad sense, especially if your MBA is a little bit more general, like just either business management or finance, different topics like that. That gives it a little bit more of a broad scope, but it does have to be related to the degree that you're pursuing. And like with any other OPT approved employer, it would be, the 20 hours per week. It has to be, you should register your business. You have to report it to your DSO or your designated school official. But one thing that I think we get a lot of questions on and a lot of students ask about is, would this apply to my STEM OPT or STEM extension? It would not. So self-employment does not allow you to work on that first STEM, because STEM OPT requires that it's an actually structured training process with supervision and reports afterward. If any of you have done that in a previous F1 state, there's reports that are required by the employer, reports required by the employee. You have to make sure your DSO is always aware of what employer that you're working with. You have to be approved for employment, different things like that. So those are the main things we want to point out with the OPT program. And I think one thing that, people, kind of forget or don't really think about is, the OPT option is great. You can definitely kind of start your business there and get things on the ground. But there's also options after that for employment visas. So like we've been talking about with the e-visa, we'll talk about a couple other options. Maybe OPT is a good way to start and see if that's working out. And if not, you want to change to a different non-immigrant visa after your program ends. That's also an option. And it depends on each individual case, but there are options even after the OPT program if it's something where you want to keep doing this business, or maybe things didn't work out and you want to start employment with a larger company. So, and if you have any more questions about that, I think I answered all those that are in the chat. The one question in the chat did say, if you're an international student expected to graduate 2026, can you register your business before graduation without OPT or CPT authorization? I mean, I think you could, Scott, unless you disagree, I think you could register your business, but if you want to work for your business, you have to have OPT approval.
Correct. I agree.
Yeah. So yeah. And then also starting the bank account and everything, you could do that as an F1 student, just give the proper information, what they're asking for. Usually it will be the business FEIN, maybe a copy of your passport, the business location. It could be other stuff, but those are just the common examples that we've seen banks ask for in financial institutions. Okay, so if we skip 2 slides, I'm going to start talking about the other non-immigrant visa options. I think the E2 was covered wonderfully. One thing I do want to point out is that if you have questions about, is your country E2 eligible, that is a quick search on the Department of State website. All of the E2 eligible countries are there. I often visit that when I'm not sure, but there's actually more on there about those treaties and information on that. If you're interested in looking at that, we're happy to give that resource to you if you're interested in looking. So one thing I'm going to talk about, there's a lot of big news about this lately, but I'm going to talk about the H-1B specialty occupation visa. That is a non-immigrant option that we see frequently coming from people that are finished with their F1. They're either in STEM OPT or they're on their STEM extension, and they get hired by a company that's willing to sponsor them for an H-1B visa. So in short, the H-1B visa is for specialty occupations that require a minimum of a bachelor's degree. And the position also has to require a related bachelor's degree for what the person possesses or has earned. It's a random lottery system. You put your name in the lottery. The company sponsors you to register. It's very employer-based heavy. But so they offer you the employment. They put you in the lottery. And what they do is they do a random lottery every end of March, beginning of April, and then you see if you're selected. So if selected in the random lottery, and I guess let me go back. I will say that, we could talk about the chances and the numbers and everything, but it's usually the 85,000 visas that are offered. We've seen multiple hundreds and thousands of applicants every year. We've been telling clients it's usually a 25 or 1 in 4 chance in the recent years, but the more applicants that are coming in, the chances are getting a little bit slimmer. So we recommend always, especially if your employer is willing to sponsor you, to enter yourself in the lottery as many times as possible. Even if you're entering the lottery, you still are eligible to do your STEM or your OPT and your STEM extension OPT. You can keep using that to work until you finally get a different visa. So we always tell people, it's a random lottery system, but the chances are, the more people that apply, the chances are becoming slimmer that you'll get selected. So, or maybe you're really lucky and you get selected the first time. So it just depends. So going back to the specialty occupation, minimum of a bachelor's degree, and the job duties in the description must be specialized. So a lot of what we see is, out of college or out of master's degree, it would be like a computer systems analyst, a chemical engineer, an electrical engineer. Those kind of jobs would definitely meet those requirements, especially if the employer is requiring a bachelor's degree or more in that. I'm not going to read through the slides. There's different lottery. The lottery works differently. If you have a master's degree, you technically get 2 dips in there. They do a master's one and then all the bachelor's degree in another one. And basically what we usually recommend is employers and employees start thinking about that around January, February of the beginning year. And if you're selected and approved, you cannot start working until the next fiscal year starts, which is October 1st of the next year. So anybody that was, for example, picked in the lottery this year for 2025, they just changed to H-1B status on October 1st. So it's one of those proactive ones. There is without going into too much detail, there is a gap option for people that are going from F1 and your STEM EAD or work authorization expired. There's a gap if you got selected from the period of your approval till October 1st. So if you were worried about that, that's also out there. But basically the H-1B visa, and I'm going to go into a little bit more detail on the latest updates on H-1B, but those are what they are. I'm assuming anybody in a master's program would be qualified for that. It's just finding the sponsoring employer that's willing to support you through that process and get you the H-1B visa to work for them. That's the biggest question. Yeah. Mm-hmm.
I just would like to add, I think a question would be, obviously getting sponsored by an employer, that's wonderful, but can you start your own business and qualify to self-sponsor my own H-1? That's a question that we get a lot from individuals in this scenario. You potentially could. It's really difficult to qualify for an H-1 with a company that you own. You really have to show that there's an employer-employee relationship with who's controlling the work. So your work would have to be controlled and directed by someone other than yourself. So that's easier said than done in most cases. But we have had clients, they create a board of directors. The board of directors has the ability to hire and fire and pay and supervise and control your employment, so that there is some employer-employer relationship with you who would be the beneficiary. Again, establishing a board to make those decisions could set you up to have a self-sponsored H-1B. Now, I'm not going to get into, I'll let you continue with the with the issues of the costs associated with those new first-time H-1s, but it's a narrow but potential option to again qualify for an H-1 with a company you own.
Yeah, absolutely. That's a great point. And Scott, if you want to weigh in, definitely weigh in, but we had another question come up, just to clarify. The question is, working without revenue or compensation, is that allowed if you're an F1 student and you're opening a business? So from what I understand the question being, can you open a business and just not take any revenue and work for it? I would say that's probably a no, especially because, I mean, unless Scott, you think any differently, but I think if it doesn't fall into the OPT, you can't work, you have no authorization to work for that business then at that point.
I think the big question there, and we see this a lot. We saw it a lot, I say, around times of COVID, where individuals were in the US under F1 status and they were working for a company or employer outside the US. It wasn't even a US, based company. And, if you are providing productive services to an employer, whether that's in the US or abroad, the government has said that is impermissible. The definition of employment is performing services for pay. You need to be paid. If you're not being paid, you might have, you're skirting tax responsibilities. The employer is not paying proper employment taxes on employees. So no, I don't like that scenario at all.
Yeah, once you get into the weeds with it a little bit, it's a little bit dicey. And the other thing I would add too is, if you're thinking about,
it's like volunteering.
Yes, volunteering. Yes, that was exactly, that was exactly my next point. Volunteering is also kind of like a dicey topic, right? So, and USCIS and immigration regulations have considered volunteering to be considered, essentially active employment. Like, you can't volunteer as an F1. It has to be approved with your OPT. It has to be, OPT approved.
I think they've come out and said that the policy is you can volunteer in traditional types of volunteer work. You can volunteer at a hospital. You can volunteer at a food bank. You can volunteer at a nonprofit. But you can't volunteer to run your, consulting company.
Yeah, working for free is not volunteering, right? And then, so let me get back into the H-1B because I know we're running short on time. But so the latest updates in the next slide on the H-1B is, I'm sure if you haven't heard of it, you will soon. It's the $100,000 fee that will be for any new H-1B applicants that are filing past September 21st. So September 21st is when it started. It was a presidential proclamation. I will say, just to preface it, at this time, the situation, and I think we bolded it here, the situation is very fluid. We don't know how this will be implemented. We don't know how this is going to keep working. We're still waiting on guidance for like the first couple of cases that have already gone through this process. But essentially, any new H-1B, we believe from the guidance that we already have, it's any new H-1B filed after the effective date, which is September 21st, employers must pay $100,000 per worker for these petitions. We do not believe at this point that it applies to people that are already approved for H-1B or that are filing extensions or transfers. But again, that is still up in the air. It could still apply to those people. So we're still waiting on guidance for that. There's uncertainty around international travel and visa processing, and if they're going to ask you for that $100 fee coming in. So our biggest recommendation to people right now is, maybe sit tight, see if what the regulations are. I know a lot of employers that we represent are kind of sitting tight before making decisions about H-1B sponsorship for 2026. But once new information and new guidance comes out, hopefully we'll get a clearer picture of how this is going to be implemented. But this is a big news hot topic item that people will definitely mention if you talk about the H-1B visa. And another
I see a question on, can open a business if someone's already on an H-1B visa? I think, as I mentioned before, as long as you can do it when you're holding H-1B status, you can file for what's called concurrent employment, meaning you can hold two H-1s with two different employers. They both can't be full-time, but you can have part-time employment. So if you're setting it up so that there is that employer-employee relationship under the H-1B with your own company, your own business, you'd prospectively then be able to have concurrent employment to work for that company. You could do a change of employer on your H-1 and move from your current H-1 employer to your new company. But again, you want to set it up to the point that that employer-employee relationship exists.
Absolutely. The other new topic surrounding H-1Bs is the weighted lottery system. So I know I kind of harped on that random lottery system before. It will still be a random lottery, but now they're going to allow for it to be weighted to favor highly skilled and highly paid individuals. So for instance, the people that are in SOC codes or wage levels that meet level 4 will get 4 entries. If you're a level 3 wage, you'll get 3, and 2 and 1, etc. It's based on the wage level the employer is offering to you. So, and this is supposed to be, the purpose of this is to favor the highly skilled workers and making sure that, before in the H-1B process, traditionally, it's a lot of F1s going to H-1B, as we said before. So it's a lot of new grads coming in, entry level wages. And the purpose of this is to favor the employers and hopefully giving them higher wages so that they get more chances of getting selected in the lottery. Will that actually happen? We don't know. It's still in review period right now. There's nothing official that has come out on that. I just saw a question about, is the 100K fee applicable to F1 students on OPT changing status? So we don't know that for sure. But you would technically be a new H-1B and a new, if you get picked in the lottery and get, your registration is selected, you technically would be a new H-1B. We're not sure if that covers F1s because they're already here and changing status. Once we get more clarity on the situation, we'll let you know. But the weighted lottery system, like I said, is favoring, it's a little bit of a disadvantage if you're coming in as a new hire right out of school, but we're going to see if this is actually implemented. And one thing I want to add is on the 100K fee, we're already seeing, as we kind of anticipated, some lawsuits in different organizations and different locations in the US that are trying to stay this and trying to fight, the regulations and the purpose of doing this. So lawsuits are already coming out. We don't know if this will actually be put into place come the lottery for 2026. But like I said, we're kind of in a waiting period once we get more guidance and clarification. And our firm does a lot of e-alerts and articles on this topic. I know that because I'm kind of, running that show. So we'll definitely be keeping clients and everybody informed. So if you have questions later on or are interested in receiving e-alerts from us, feel free to reach out to me. I'm happy to do that for you.
I see another question just on
sure.
F1 students and can they apply for grant funding or participate in pitch competitions? And I'd say yes. I think F1s can apply for grant funding. I think it's important just to note that eligibility for that specific grant may require U.S. citizenship, a permanent residency. My best advice there would be to consult with the school's DSO to ensure that the funding wouldn't violate your visa status. Again, external grants should not involve unauthorized employment. And honestly, and Ala may know better than I, but the university department or ISO may have internal scholarships or grants or fellowships that are specifically designed for international students that you can take a look at.
Perfect. Yeah. So I'm going to briefly talk about the other types of visas because I know I want to get you guys done in the hour. So next would be the, after H-1B, we want to talk about the O-1. So the O-1 visa would be next, and that one is for extraordinary ability individuals. This one does not require, a job offer or like similar to the H-1B, you don't need an offer of employment here, but you do need to meet the qualifications, at least 3 of the 5 that we listed below. I will not go through all of them, but these are the extraordinary ability. It's the highest level of scrutiny from USCIS we've noticed. And I personally think these are the hardest to get approved unless you have very good evidence. I have gotten many approved. A lot of them are, if you have patents, that's great. People that win international awards, that's more like, like big prizes, big renowned prizes. But if you have a lot of articles that you've published on your topic, if you've been quoted in your publishings on topics, if you judge the work of others, like you read other people's reviews or judge any competitions or anything like that, that's a big one for this one. But yeah, these are the extraordinary ability requirements. And I think that bleeds well into the next topic, which is the immigrant visas. There's an extraordinary ability immigrant visa option as well after this. And it's called the EB1. And for that one, you can go to the next slide, Ala. And we kept L1 in there. Okay, so we talked about L1s. We're going to skip past that. We talked about the intercompany transferees.
I mentioned EB5 already. Yeah, I mentioned that already. You can skip over that as well.
Yeah, absolutely. Yeah. So I'm just going to mention, and I'm not sure why that slide is not in there, but we just added the EB1 and the EB2 in there as well, along with EB5. But EB1 is the extraordinary ability individual that would be the same requirements as the O1 that we just went over, but that's on the immigrant visa status. So that's more looking for permanent residency requirements, and then versus the O1 is the non-immigrant visa that's more temporary. And I will say O1s are generally allowed in increments of 1 year periods. Once you get past the first O1 stage, we usually tell people to think about the EB1A because they've already met the criteria and requirements for that.
I think that's really important. Sorry to interrupt, but this was going to lead into the question that I see as well. So as Beth mentioned, the O1 is a temporary visa that can be issued for 3 years and then extended in 1 year increments. The EB1 is the same exact criteria, but it results not just in a temporary visa, but in a green card. And there is a pathway. If you're coming from STEM OPT and you can qualify for the O1 criteria, you might be able to qualify for the EB1 criteria. Again, it's judged a little more significantly on the EB1 side because the end result is permanent residence as opposed to a 3-year visa. But you certainly can see if you have those qualifications in those categories, as Beth mentioned, absolutely, there's nothing to say you cannot attempt that path directly from STEM OPT to EB1 with those publications, awards, prizes, significant achievements in your field. So
yeah, absolutely.
I don't think this is the right deck. We'll update the deck and I think we had 2 versions, by the way. We just got to send her the other one. And
yeah, I will for sure. And you could resource that to everybody. But yeah, so briefly, EB1 is that same as O1. EB2 would be the natural interest waiver. And we could talk more about that. But that's if you believe that your work and your presence in the US is in the national interest of the United States. We've had a lot of people successful in that route. We've had a lot of people that have also tried that route and decided to go another way. But that is a path to getting an immigrant visa. And then EB5, and we did talk about the entrepreneur rule with parole, and I think that was well covered. That's also an option, but just offering someone parole. And then Scott did cover the EB5 for investors, and that's something if you're interested in doing that, it's something we help out with a lot. We usually pair up with the person, identify their goals, and then think about the investment they want to invest into the United States and kind of go from there. It does give you a path to a green card. So
one last thing I mentioned about the EB5, a lot of folks look at this and they say it's $1 million bucks, it's 800,000. I don't have that kind of money. What am I going to do? How is that even a viable option? Well, honestly, the immigration rules have changed for EB5 a couple of years ago, where it allows for loans or gifts. You may have your own business that you start up in the US and, maybe you're actively running it under a visa, maybe you're not, but you could take out a loan. You could take out an unsecured loan. You could take out a secured loan and use that capital through that loan to qualify for the EB5 program. We find a lot of foreign students, whether they get money through gifted to them from family members or friends, they also can look and have explored, many of them explored this option to get a loan. The EB5 program, when done properly, results in repayment of that initial investment after the green card is obtained, your permanent green card is obtained. So it's not as if you wouldn't have those funds prospectively to then repay that loan. So it's not completely out of the question. I just throw that out there because sometimes folks are like, why are we talking about this? So if I had that money, I wouldn't be talking to you as right today. So I just wanted to add that path, if you will.
Absolutely, yeah. And I think that's our time, a little bit over, but yeah, if anybody, I see a question in the chat. F1 student has a citizen.
Yeah, I mean, listen, I think in that scenario, that question, I think the U.S. citizen would want to be the employee co-founder. Prospectively, if for you to actively perform productive services for that business, you really should have the OPT. I'd even talk to the school about maybe there's a CPT option or maybe course credit for it or something along those lines. But you're really individually as an F1 solely on the F1 visa, it does not allow for employment or even as we talked this volunteering scenario. Having the OPT would bridge that gap a little bit.
I hope that answers that question. But if any other questions come up, happy to answer those, please reach out to us. We'll give you our contact info. We're sending it to Ala. But yeah, these were great questions and what a great dialogue. I think these are very interesting topics, and I think they apply to everybody individually, a little bit differently, but we're happy to kind of dig into your case if it's something you're willing to, want to pursue, or if you're at the point where graduation's coming up, you want to think about next options, we're happy to talk to you about that.
Yep. Specific situations, feel free to reach out. So.
Mm-hmm.
Thank you so much. I know this is a huge topic, and 1 hour is just barely scratching the surface. So thank you for being able to actually pick all of the relevant pieces of information and put it together. So thank you so much, Scott and Elizabeth. Fantastic presentation, very useful. I know it's going to get a lot of views on our YouTube channel, so I'll let you know when it's uploaded. But thank you so much to everybody for great questions. I will circulate. Let me know if you would like to receive a copy of the presentation. I can share the slides. I'll probably wait for you to send me an updated version.
Yeah,
absolutely. Yeah.
I'll do that. And please come back for additional sessions that we have planned for our Startup Fundamentals workshop series this month and next month. Again, thank you so much, Elizabeth and Scott, and thank you for Cozen O'Connor to being a great contributor to our workshop series this year.
Thank you for having us. It's a pleasure.
Thank you.
Thanks so much.
Thank you.
Bye-bye.